the possibility of tallies in Forms 34B conflicting with the results in Forms 34A cannot be ruled out, and the second respondent would be properly guided if it is clarified by the court what results he should declare between the tally of the results in Form 34B and the verified tally of the results in Forms 34A at the National Tallying Center. The second respondent further urges the court to find that it has jurisdiction to make the clarification sought for purposes of creating certainty and ensuring that the second respondent is clear on what this court considered to be the valid results in accordance with the provisions, spirit, and the intention of the Constitution. The second respondent's position above was reiterated by his advocate, Mr. Karori Kamau, when he orally highlighted the submissions before court. Learned Counsel thus pointed out that the petitioners had, in their grounds of objection to the application, acknowledged the possibility of the discrepancies alluded to by the second respondent, and the petitioners had gone a step further to give the understanding of how to resolve any discrepancy by approaching the election court. Counsel further argued that the second respondent seeks to avoid a situation where he would willingly be made to read incorrect results and anticipate an inevitable petition arising out of the second respondent's actions. Elections being a highly emotive issue, Counsel submitted that the second respondent has disclosed an issue that he is likely to encounter, and the court should clarify the same. The first respondent submissions. The first respondent relies on its submissions dated the 10th of October 2017, in which they submitted that the clarification being sought is in respect of the following two issues. Firstly, which results between those declared in Form 34A at the polling station and those declared in Forms 34B at the Constituency Tallying Center should the second respondent rely on in declaring the result of the presidential election. Secondly, in conducting verification as directed in the judgment of this court, can the second respondent alter the Forms 34B where the same differ with the results as declared in Form 34A? It is in their submission in the above regard that the clarification sought is in respect of the manner in which the officials of the first respondent are to manage the presidential election results in the event the verification exercises envisaged divulges inconsistencies and or clerical mathematical errors between the results declared at the polling station and the subsequent tallied results. The first respondent makes reference to the minor KI decision with regard to the verification of the presidential election results and submits that from the judgment of the Court of Appeal, the presidential election results declared at the polling stations were final, and the first respondent could not verify or vary the results. Further, that the role of the second respondent in the verification of the results was restricted to confirmation and verification that the candidate to be declared president-elect has met the threshold set under Article 138(4) of the Constitution, whereas the Supreme Court had allegedly held that verification of election results is conducted by the first respondent as follows: the presiding officer at the polling station, the returning officer at the constituency level, and the chairperson at the National Tallying Center, to be found in paragraphs 283, 286, 287, and 290 of the judgment.